Hi, my name is Justin Levitt. What you're about to see is a simulation of the entry-level interview at the AALS Interview Conference in October in Washington, D.C. There's a companion video that lays out one version of this interview in a bit more straightforward fashion. The interview you're about to see indulges in some more unusual or more confrontational or more off-key questions. Please keep in mind this is a simulation only, and the interviewers, the questioners, are all taking roles here. These are not the questions they themselves personally would ask, but they hope to present some scenarios that you might see in order to better prepare you for what might come. I want to thank my colleagues at USC and Southwestern and Loyola Law School for participating in this video. I particularly want to thank Priscilla Ocen, who's serving as the interviewee. She is an exceedingly distinguished tenured professor of law, and so you will see her answer these off-kilter questions adeptly and with a bit of humor, responding to the questioner when they've been indulgent, when they've been talking about their own areas of expertise, when they've been a bit antagonistic, and then turning the questions back around to her own research and her own areas of expertise in truly expert fashion. You will also notice that Professor Ocen begins the interview by explaining candidly that she's got another interview coming up, and therefore alerting the interview committee to the fact that she has to leave right on time in order to make her next appointment. She does it straightforwardly and without apologizing, but allowing the interviewers to understand that there's a hard deadline. That is also entirely fine and a wonderful model. We hope that this simulation is useful to you. We hope that it's instructive, and we certainly wish you the very best of luck. Hi, Priscilla. It's so wonderful to have you here. Thank you so much for coming. My name is Justin Levitt. We spoke on the phone.
I'm Cindy Archer. Thank you for coming, Priscilla.
I'm Franita, Tolson. It's really nice to meet you.
I'm Daria, Roithmayr.
I'm Mike Dorff. Such a pleasure.
Great to meet you all. And I'm so pleased to be here. And I just wanted to let you know that I have another interview in about 25 minutes. So my apologies if I have to run out of the door.
No, of course. We'll make sure to get you out of here on time. Thank you.
Okay.
So we know time is limited. And I want to talk first about the paper that you put before us. And we've read it. I've been assigned to read it primarily, to really dig into the details. But before I start articulating what your thoughts are, I'd much rather hear it from you. How would you describe the project that you've got here?
So incapacitation is one of 4 central theories of punishment. And in this paper, I argue that incapacitation is one of the ways in which women are regulated. Their reproductive capacities are subject to punishment by the state, and as well as their gender identities. And I map out the ways in which that is the case throughout the history of women's prisons in the United States.
You do it by actually going through quite an impressive history, and then by looking to doctrine, and then by looking to potential policy going forward. I mean, it's really quite an impressive canvas. But the end of the paper sort of lays out a more utopian world in which we've all sort of agreed that this regulation is bad, and we've actually brought forth the resources that women need in prisons and such. How do we get from here to there? What's the next step along the way?
All right, so one of the things that I do in the paper is to talk about how, for example, in much of the scholarship, incapacitation has been described as a driver of racialized mass incarceration, right? And in the paper, as I just said, I talk about the way incapacitation has been used to regulate the reproductive capacities and the gender identities of women. And that's been facilitated largely in part by legal doctrine, by substantive due process, by the failure of the Supreme Court to protect the right to parent, the right to procreate. And so at the end of the paper, I describe a new way of thinking about the right to parent and the right to procreate in its relationship to women, especially women who are incarcerated, and that's reproductive justice. And in reproductive justice, it's not simply a way of looking at the right to parent and the right to procreate through a legalistic or doctrinal lens, right, or through a negative rights framework, which is to say the state may not burden the right to abortion or burden the right to contraception or burden the right to parent. It also says that individuals have the affirmative right to parent and have the affirmative right to procreate, and that the state must provide substantive support for people to procreate and to parent with safety and dignity.
And is that a legal claim, or is that a
No,
claim
it's
that-
not firmly a legal claim, right? Under reproductive justice, it is both a moral and legal claim, right? So it calls upon the courts to support a framework in which there are negative rights, in which the state may not burden rights, but there also is an affirmative, there's also a call for a development of a doctrinal affirmative right to support for parenting and procreation. So yes, in that vein, there is an affirmative call for an affirmative right to support. But on the other end of the spectrum, in the context of reproductive justice, there's a call for organizing, for policies that provide for robust housing support. So it's not just about prisons, it's about the kind of world that must exist in order for people to be able to make informed choices about their body. So how do we get back to prisons, right? The idea is, if we're talking about women who are incarcerated and women who want to make choices about their reproductive capacities and any children that they may have or that they may want to have in the future, we need to provide them with support while they are incarcerated. So that looks like policies, for example, in Minnesota, where the state legislature, based on organizing by women of color in that state, provided doula support. It looks like outlawing, prohibiting, either by legislation or by, for example, litigation under the 8th Amendment, the practice of shackling pregnant prisoners. It looks like litigating or legislating affirmatively the right to access medical care while pregnant, or to access reproductive care while incarcerated, ensuring that people have access to visitation, so their children and other family members. So these are the kinds of things that I think are firmly within the under the framework of a reproductive justice framework that I think would support the rights of incarcerated women, to enable them to exercise their reproductive choices and to exercise their right to parent with safety and dignity in ways that the doctrinal frameworks that have existed, that the courts have used up until this point, have failed to do.
So I have a question about the general framing of the project. And I think part of my complaint has to do maybe with a theoretical approach more generally. And so when I listen to you talk about, for example, termination of parental rights, in my civil procedure class, I teach the Lassiter case. And my students are all pretty agreed that Abigail Lassiter is in prison for murder. She hasn't pursued connection with her son William for 4 years. And in their view, and it's certainly a plausible argument, incarceration is incompatible with parenting, and that it would be far better for baby William to be placed with the foster family, and it would be in their best, it would be in the child's best interest. And so when I think about critical race theory as an approach to this question, I worry that the ideal scholar approaches a topic with neutrality, with some objectivity. And that objectivity might lead one to conclude that, on balance, incarceration is incompatible with, or often incompatible with, the best interests of the child, especially where termination of parental rights are concerned. But because critical race theory already commits in advance to a particular political commitment having to do with race, having to do with a description of the victimization of black women, that you're not going to see that potential argument because you're not sufficiently objective.
Right.
What am I missing?
Well, I think that, one, I would push back on the idea that critical race theorists aren't sufficiently attuned to various alternative arguments that are inconsistent with a view about subordination and state power. I think any scholar worth their salt will take into account contrary views. And that's certainly the case with any critical race theorist. And the idea that anyone is objective, I think, is one that can be contested, whether you're a critical race theorist or not. But to the point about what's in the best interest of the child, it's not whether you're a critical race theorist or not, it's looking at the literature on child development. Child development scholars say that separating parents, even during periods of incarceration, is not in the best interest of children. And for the most part, children who are separated from their parents during periods of incarceration are not actually placed with a loving caregiver, which is, I think, what most people would imagine happens. What happens is they languish in foster care, where they often are subject to abuse, where they're often neglected themselves. What
is the methodology of critical race theory? And so you're not a psychologist, you're not doing original research on psychology in terms of child development. You're a critical race theorist. I don't know what that means and methodologically how I'm going to get to the question or the answer of what to do about motherhood in prison.
Well, so to back up, critical race theory is at base an internal critique of law and the way that law constitutes race and the way that law constitutes power, right? So that is the inquiry of critical race theory. And it's not just critical race theory, it's critical legal studies. It also comes out of a canon of legal realism. So that's the basic inquiry of critical race theory. So that's separate from the question of whether or not I'm a child development scholar, right? So legal scholars generally are interdisciplinary in nature, right? So if you're a scholar of law for law and economics, for example, many legal scholars in that arena are not economists. They draw on the literature from economics, right? So in the same way, critical race theorists, in many respects, draw from scholarship in a number of different arenas as well. We draw from sociology, we draw from economics, we draw from child development, we draw from psychology, right? All to help us to understand the way in which structures reproduce themselves. They reproduce inequality, and they reproduce race as a social structure that produces social outcomes that are, I think, not socially optimal.
I'm so glad you raised law and economics, because when you talk about the operations of prisons, I'm a corporate law scholar, so I don't know anything about prisons, but one thing that occurs to me is that in many ways they're kind of like corporations, in that you have someone who's in charge of the prison, you have a warden who's in charge of the prison, and there's a lot of day-to-day decisions that have to be made right then and there by the person who's on the spot. And you don't really want a court second-guessing all of those decisions after the fact. Just like in corporate law, we have something called the business judgment rule, which says that we're going to defer to the board of directors on most issues because we don't want courts intervening unduly. And one solution to that of how to change the behavior of corporations has been raised in terms of executive compensation, that if we pay people based on their outcomes, then we'll get better outcomes. And so I wonder if you've thought about the pay structure for wardens in prison and whether the pay structure could be modified to achieve many of your ends and thereby keep the courts out of it.
That's an interesting question. So, you know, the court has been largely deferential to prisons. In Turner versus Safley, the court announced essentially a rational basis approach to prison regulations, which is very different than the way it approaches many other social structures, particularly as they touch on issues related to fundamental rights like reproduction, marriage, for example, the right to parent, and others. So the court acknowledged, from the court's vantage point, it believes that the management of prisons is highly specialized, technical, and outside of its competency. And so they do defer to prison officials with regard to how to keep prisons safe. They're slightly rolling that back recently in a case called Plata versus Brown. The court ruled that, for example, California's prisons are overcrowded, and as a result, causing needless death and suffering, and ordered the reduction of the prison population by about 40,000, and that's a significant departure. But to your question about compensation and whether that would change the incentives for prison officials and therefore change outcomes in prisons, I'm not so sure that that works. So we have a model of private prisons in addition to public prisons. And private prisons are, I'm trying to figure out a way to say this, they have just been a mess in terms of human and civil rights violations. One of the largest corporations is called the Correctional Services, and actually one of the cases that I cite in the paper is called Nelson versus Correctional Medical Services. They have been sued over and over and over again because the profit motive is precisely what produces the violation of constitutional rights, right? The idea is to try to produce a product, which is the prison, for as low a cost as possible to increase shareholder profit. And that comes at the cost of human dignity and safety. And so it's actually the opposite when it comes to prisons. And so when it comes to courts and their relationship to prisons, I think what needs to happen is the opposite. Courts should be less deferential to prisons and more aggressive in their oversight, especially of private prisons.
I think I want to transition to talk about some of your background, away from the research you're currently doing. I see that you worked with the Lawyers Committee for Civil Rights. It's a wonderful organization. I worked there myself actually years and years ago, and I've got a bunch of friends there. Who are you primarily working with?
I primarily worked with Robert Rubin and Kendra Fox Davis.
Wonderful.
Yeah, he's a great person.
Do you speak to him much?
I do.
Still?
Every time he comes into town, he'll give me a call when he's working on various voting rights cases.
Yeah. Well, I remember a story. He used to talk about going into court, and he's got a very mild-mannered, really soft-spoken approach. And sometimes he was telling me about the fact that it works really well with judges, and they sort of lean forward to hear him, and he took his advantage. But occasionally they mishear what he's saying because he's so soft-spoken, and that gets him in trouble sometimes. There's so much there with Robert. What were you primarily working on when you were there?
So actually, that's where I started to work on prisons. While I was there, we had a new executive director named Latifah Simon. And when I came in, I had just came off of a project in law school called the Prisoner Reentry Initiative, where I worked with a woman named Susan Burton, and I was very keen to continue that work. And so I started to go into women's prisons and hearing their stories about the conditions that they were experiencing, the medical neglect, the loss of child custody, experiencing with shackling, for example. And so based on that, we started to take on cases related to conditions of confinement, working with colleagues in the Bay Area. I worked on cases related to police misconduct and police harassment of women on Section 8, which ultimately has become a part of my research agenda as part of a forthcoming paper on the harassment of Black women on Section 8, which I'm calling the new racially restrictive covenant. And I started to work on a Black Women's Reentry initiative, which has created an area of my own scholarship related to community supervision, women on probation and parole. So that experience at the Lawyers Committee really helped to spur my interest in the impact of mass incarceration on women and girls, and the way in which prisons regulate the reproductive capacities of women and girls. And that's where I saw very clearly how devastating prisons are when it comes to women's ability to protect their rights to their children.
I ask, most of your experience seems to be in larger metropolitan areas, California, New York in particular. We are definitely a strong research institution, our university as a whole, but in a little bit different environment that some might call a little bit more conservative. We haven't had anyone do anything in the area of critical race theory. So I'm curious what challenges or limitations you feel that might put on your ability to continue your research in this area. Again, we're a supportive school, but I just see that might be a limitation transitioning to the smaller town environment, kind of college town environment in the Midwest South area where we're located.
Well, I will say that I have spent time in some smaller cities and towns. I spent summers, for example, in Montgomery, Alabama, and Jackson, Mississippi. And while I was clerking in Detroit, I spent a fair amount of time in Ann Arbor, Michigan. So I enjoyed my experiences in those environments, especially coming from a city like Los Angeles, where it can take you 2 hours to go 2 miles. So I did enjoy, that pace. So in terms of my ability to be in a smaller setting, I have no doubts about that. In terms of my ability to integrate myself into a faculty where you haven't had anybody teach critical race theory, I'm happy to come and to really help folks understand what critical race theory is and also what critical race theory isn't. To really help students to understand the analytical framework of critical race theory and to bring it to bear in a number of different fields. I suspect that I'll be quite busy at the campus, but I would also look forward to getting to know the community and contributing to the vibrancy of the campus community as well. So
I think what my colleague is trying to ask you about, maybe a little opaquely, there are some of our colleagues who would say you shouldn't do critical race theory work until you get tenure.
Mm-hmm.
How are you going to pursue your kinds of scholarship? Is there a scholarly agenda that you have that wouldn't involve critical race theory? Your criminal work on a more kind of straight doctrinal methodological approach?
No, I think the work that I do involves criminal procedure, it involves criminal law, it involves insights from critical race theory, so it involves all of the above. It involves, I am deeply influenced by intersectionality, and it's not an identitarian approach. It's an approach that looks at power and how power is constituted. Through the way in which identities are constructed. And that's very important to my work on, for example, how Black women are subject to policing and punishment. So I can't do that work without the tools of critical race theory, intersectionality, but I also can't do that work without the tools of, for example, theorists of criminal procedure or criminal law. So no, I don't think I could do the work that I want to do without critical race theory or intersectionality. But as I said, I also couldn't do it without the insights of criminal procedure, other doctrinal areas that I'm interested in pursuing as well.
Do you think intersectionality is played out? I mean, isn't it just about layering identity on identity? So poor Black woman, lesbian, disabled, what insight do we get from all those layers?
No, I don't think it's about layering on identities. I think it's about a critique of structures. It's a critique of power. And so looking at where particular people or communities are located vis-a-vis structures is what intersectionality helps us to understand. So for example, if we're talking about prisons, it helps us to understand housing, it helps us to understand policing, it helps us to understand welfare institutions and how poor Black women, for example, are impacted by these various institutions. So it's not about the poor Black women, it's about welfare institutions, policing, prisons, housing, employment. That's what intersectionality helps us to understand. It's a critique of power, not construction of identities.
So how would you deal with a student who would resist the idea that any of this matters? Right? That race and gender are sort of categories that are pertinent to understanding any of the substantive areas that you study?
I have encountered those students. And, you know, some of them are just sort of quiet and they don't want to engage. And I try to be patient with those students and talk to them separately from the rest of the class to the extent that they want to engage. You can't force people to engage. And to try to talk to them in ways that maybe they can understand from their own vantage point. So, for example, white students, for example, may feel threatened or feel that their experience is invalidated if you talk about, for example, if a subject of white privilege comes up, for example, or whiteness comes up. If I teach, for example, in critical race theory, one of the canonical texts is by Cheryl Harris, an article that was published in the Harvard Law Review called Whiteness is Property. That brings up quite a bit for some students. And they often will resist discussion of that piece. Not because of the substance of the piece when we're sort of walking through it. They often will acknowledge that the arguments, which are very rigorous, that are presented in the piece in terms of the historical analysis, the legal analysis, the economic analysis of the piece, or, for example, some of the work of Daria Roithmayr, right, on racial capitalism or racial monopolies, right? Those are, the analysis that's presented in some of that work is rich and well-reasoned. And historically accurate. But at the same time, it's a challenge to them because they seem to think that somehow it implies that they have undeservingly benefited from their whiteness, right? So in some ways, it's about having a conversation about what the implications of that work is for them personally and helping to disarm that so that they can really hear what the implications of the analysis are. So it's less personal for them in some ways so they can really hear it. But I also don't want to spend too much time doing that because I also have other students that in many ways want to learn the material. So it's a balance of being able to really attend to a student that really could benefit from the analysis of some of the material that I may teach in, say, a critical race theory class, with the students that come into the class that really are invested in learning the material. I think where it's more important, and not more important, but I think where it's really important is, for example, in a criminal law class, where we're talking about issues, for example, of race in the context of self-defense. And that's where I think those sort of sensitive subjects are really important to manage, or, for example, where you're talking about rape. Those are very sensitive topics that need to be managed in a way that takes into account the various perspectives in the class. And so when I lead discussions, I try to treat the students like lawyers and ask them to take on perspectives that may not be theirs and to argue contrary positions, so that I'm not asking them to agree, but to really think about all the different aspects of an argument, to maybe even if they don't agree or they don't think that it's something that is a part of their experience, to be able to articulate what the argument is. And again, when we're talking about, for example, something like race and self-defense, to try to bring forward some of the background materials so that the students are on the same page, but also trying to prime the discussion so that the students can have a sensitive conversation about it as well.
So I really want to thank you. I know we're short on time. I want to be very respectful of your time. Thank you so much for coming in. We really appreciated having you here. We look forward to being able to answer any questions. I want to make sure we get you out of the door on time.
All right.
But please feel free to get back in touch with us about any questions you might have whatsoever.
All right. Thank you very much.